morning. Here I am in my tool room, surrounded by putty knives, clamps, miter saws, and nail guns. So what does this have to do with today's video? Well, I'm glad you asked. Today's video, the recently proclaimed Construction Act and its impact on small claims. The changes to Ontario's Construction Lien Act, as found in Bill 142, are expected to come into force on or about July the 1st of 2018. So what does this mean for lawyers and paralegals who practice in small claims court? What does Bill 142 have in store for lien claimants who are owed $25,000 or less? Well, those two questions are what this video addresses. Let's take a look at Part 8 of the Construction Act, in particular Section 58 Sub 1, where we see that on motion made after the delivery of all statements of defense, or the statement of defense to all cross-claims, counterclaims, or third-party claims, if any, or after the time for their delivery has expired, a judge may refer the whole action or any part of it for trial, and in particular, under subsection C, if the action is for an amount that is within the monetary jurisdiction of the small claims court, as set out in Section 23 of the Courts of Justice Act, to a deputy judge of that court or to the small claims court administrative judge. Under subsections 58 sub 4 and 4.2, we also see that a deputy judge or the administrative judge of the small claims court has all the jurisdiction, powers, and authority of the court to try and completely dispose of an action that has been referred on motion. The amendments to the Construction Lien Act under Bill 142 do not allow for the perfection of a construction lien by way of issuing a plaintiff's claim in small claims court. Just like previous, claims must be perfected by issuing a claim in Superior Court. We have to remember that a small claims court receives its jurisdiction under Section 23 of the Courts of Justice Act. We saw in a previous video that under the Courts of Justice Act, subsection 23(1), the small claims court has jurisdiction in any action for the payment of money, and also has jurisdiction in any action for the recovery of personal property, provided that the monies claimed or the personal property to be recovered has a value of $25,000 or less. As a result, the small claims court does not have jurisdiction to deal with real estate or construction liens. The lien component, perfecting the lien, and issuing a certificate of action are all within the exclusive jurisdiction of the Superior Court. So what do these amendments mean for paralegals? Under Section 67(5) of the current Construction Lien Act, there are provisions that may lead one to conclude that paralegals can preserve and perfect construction liens in Superior Court, provided that the amount claimed is under $25,000. If we look at subsection 67(5) under the Construction Lien Act representation, we can see that a lien claimant whose claim is for an amount within the monetary jurisdiction of the small claims court may be represented by a person authorized under the Law Society Act to represent the claimant. Now, this may give us some glimmer of hope that paralegals could represent lien claimants in Superior Court, but that in fact is not the case. As it turns out, the Law Society has not authorized paralegals to deal in construction lien matters under the Law Society Act. In a regulatory meeting conducted on November the 23rd of 2017, the Law Society made it clear that construction lien matters fall outside of the scope of a paralegal license. In any event, subsection 67.5 is to be repealed once the new Construction Act is enforced. So what type of impact will the Construction Act have on small claims court? Probably not much impact at all. From time to time, a trial may be referred by a Superior Court judge to a deputy judge or administrative judge of the small claims court. Other than that, it will remain relatively expensive for a lien claimant who is owed $25,000 or less to perfect a lien under the Construction Act. As for lawyers and paralegals who practice in small claims court, it certainly isn't likely that the provisions of the Construction Act will open a floodgate of new files. So,